matter of Johnson and Secretary of State for the Home Department.
Yes, Mr. Metzer.
May I please, my lords and my lady, I represent the appellant, together with my learned junior, Dr. Russell Wilcox. My learned friend Andrew Deacon represents the respondent.
Mr. Deacon, if I'd got here in time, I would have suggested that you came to the front row as well, but you said that there is, as it were, topographical equality, but you're welcome either to stay there or move to the front row, whichever you like.
Thank you very much, my lord. I'm happy to stay.
Mr. Deacon, I know won't say this himself, but he's recovered from quite not been at all well the last couple of weeks, as my lord I think knows, and I hope you won't need to have a break, but I alert the court just in case of any difficulties.
I hope so as well.
Yes, very much.
My lord, can I just establish that you have an additional short document which I think will be of some assistance because
Yes.
it helps, I think, in terms of the chronology of the matter, and I propose to refer to that in passing. Can I assist the court by indicating that I don't propose to deal at this stage, unless the court requires otherwise, the res judicata point raised in our, which we defend, I think, essentially in our skeleton, in our supplementary skeleton. It's obviously a matter my learned friend may develop, and I've certainly been positioned to deal with it, but I don't propose to deal with it unless the court thinks otherwise at this stage. And can I also indicate that I wouldn't call ground 4 of our submissions to be exactly a coverall, because the adequacy of reasons point is standalone, but I propose primarily to focus on grounds 1 to 3.
Yes.
Can I also say this, that we wholly accept, and I really need to spend longer on it, and indeed it's common between the parties in terms of delay in the judgment, we recognise delay alone won't get us anywhere. It has to be delay compared, added to other substantive grounds in relation to the period of time the judgment took.
Yes.
So I don't propose to spend long on that point, although it is something I'm sure the court would have noted. So summarising the case in short in terms of the background, and I will need necessarily to take the court to some documents because the history is of some significance. This is the appellant's argument in support of its appeal against the judgment of Mr. Justice Sweeney, handed down on the 7th of December 2022. I don't think I need at this stage, I shan't take you to that, it's a page 140 of the main appeal bundle. Permission to appeal on all grounds was granted by Lord Justice Newey, 19th of May 2023, 229. The judgment followed the trial of the appellant's claim for unlawful detention in the period between the 21st of July and the 23rd of July 2021, a 3-day trial, arising out of his immigration detention for a relatively substantial period between the 16th of February 2014 and 19th of June 2015, and an attempted removal to Uganda in December 2014. And I shall come to that in due course.
None of your grounds of appeal relate to the harassment claim, as I understand it. It's just the unlawful detention.
That's right.
Yes,
yes, exactly. There was one admitted period of unlawful detention. On all other grounds, the appellant's claim was dismissed. Pages 235 to 236 of the appeal bundle. The background was that the appellant's mother arrived as a visitor in the United Kingdom on the 1st of October 1989, together with the appellant's 2 siblings. The appellant himself was born in the United Kingdom on the 24th on Christmas Eve 1989 in West London. The family claimed asylum on the 3rd of January 1991, refused a period of 6 years or so later on the 5th of March 1997, and on the 21st of April 2000 the family were refused settlement but were given a further period of exceptional leave till the 25th of March 2002. There was an application made by the family for indefinite leave to remain on the 22nd of June 2006. At that time, the appellant's birth certificate was submitted along with what purported to be his Ugandan passport. It's probably worth...
So did you say the 22nd of June 2006? I thought the application was 2005, according to the judgment of Mr. Justice Sweeney.
There was a family application for indefinite leave. I think it was the 22nd of June 2006. We can check that date, of course, my lord. Can I take you, the court, please, to the appellant's birth certificate? That's at the supplementary bundle at pages 83 to 84. So you have two documents there at the supplementary bundle. You have the document at page 83, which purports to be, and it's the front page of an Ugandan passport, and then page 84, which
So
is...
when you say purports to be, just to be clear, I understand it from the judgment of Mr. Justice Sweeney, this is a photocopy of the original passport supplied by the mother and issued to the claimant. So when you say purport, it was the passport. Whether any of the details in it are right or wrong is another question, but it was the passport that the Ugandans issued. Was it not?
I've asked for instructions from a learned junior, precisely, of course, who dealt with the case of the court below, and I've asked for the circumstances under which this document was submitted. We simply don't know how it came to be. The appellant just simply doesn't know how it came to be that his mother had relied upon this document. If my lord is asking, did it at the time purport to be a genuine document, and it clearly isn't, yes, that must be right. But how it came to be presented as a genuine
I understand it from the judgment, and you have to, if you're going to say the facts are wrong, that's quite difficult. The judgment says that the passport was issued to him when he was 12, so presumably his mother or father applied for it, and this was the document that they issued.
Well, it was certainly a document which was presented
By the mother.
by the mother.
Yeah.
I don't think we can go as far as to say that we don't know what happened in terms of how it came into existence, but I wholly accept, my lord, that it was presented as a document purporting to come from the Uganda. Yes, that's absolutely right. On page 84 is the appellant's actual birth certificate, and you'll see there that he was born on there in West London, in Park Royal. As my Lord Justice Lewis correctly ascertains, at page 83, it appears from the document that this is a genuine document because it makes a reference to his birthplace being Rurewa in Uganda, and that is simply incorrect. We understand, and we can't say for definite, but we understand, because the appellant has lost touch with his family, that the appellant's mother and siblings did acquire settled status, but the appellant's indefinite leave to remain application remained outstanding. On the 12th of November 2010, the appellant, who was then aged 21, was sentenced to 8 years imprisonment upon conviction of the Harrow Crown Court for serious offences of aggravated burglary and assault. I'm looking also at the key documents document to assist the court. On the 9th of January 2013, there is a CID note, and we'll go to that, of the respondent, which is a photocopy of the Ugandan passport on the file. So that's can be found at 357 of the main bundle.
When you say main, is that the core of the supplementary?
Core bundle, sorry, I should use the word core.
Page
357.
Thank you.
The court will see there that it's a CID note of the 9th of January 2013, reference to the offence for which he'd been convicted in 2010. And then one will see there in the second paragraph in the main section, it is noted that there are 2 copies of full birth certificate stating that the appellant was born in the United Kingdom on the 24th of December 1989. No father is declared. And then if you drop down 3 further paragraphs, it is further noted that there is a photocopy of the Ugandan passport, and document we've gone to, issued 6th September 2002, which for him, date of birth 24th of December 1989, so it's the same birth date. Place of birth, Rwera, which contradicts the birth certificate submitted later. So the CID note is recognising at the outset the inherent contradiction between the two documents. On the
Where are the birth certificates saying he was born in the UK?
if you go back to page 84, my lord, of supplementary bundle,
Yeah.
do you see there under 1, date and place of birth? 24th December 1989, Central Middlesex Hospital, Park Royal.
Oh, I see. Section 8 says place of birth Uganda.
I think this, the difficulty is that on the face of these two documents, they can't both be right.
So even the birth certificate, my lord is pointing out, can't be right because box 1 says Park Royal, which is London, and box 8 says Uganda.
Yes,
Oh, is that the mother's place of birth?
that's the mother, I think, Juliet.
Oh, I see.
So I think it's impossible to square the two documents. They can't both be right. I think that was recognised by the CID note.
Thank you.
So to hesitate to rise, but just for the point of clarity, my learned friend mentioned the date as the 9th of January 2013 of that document, which is what the date is headed. But if you'll see in the judgment, excuse me, of Mr. Justice Sweeney, paragraph 17, this was discussed in the hearing and it was actually 2014. I don't know whether that's relevant, but if your lordships are making a note, this is a misdated document.
I'm perfectly willing to accept that. I don't think it makes any, if anything, it's actually more consistent with the chronology thereafter. Yeah, onto that. So yes, that should be amended. I'm perfectly happy. 9th of January 2014, that's a clear typing mistake on the document. So now that actually makes more sense because on the 17th of January 2014, the appellant's outstanding application for indefinite leave was refused, to remain was refused. He was served notice of liability to deportation on the 22nd of January 2014. On the 27th of January, 5 days later, the appellant's detention was authorised under immigration powers following the end of his custodial sentence, and you can see that at the core bundle at 367. The document starts at 364, but at 367 is the decision and the authorising. And you'll see the page before, the minute of decision to detain on the same date reads, his removal could not be realistically expected in the near future. My lords, my lady, will see that middle of 366. It's the just after the last bullet point. An ICD facts were served 7th of January. Therefore, Mr. Johnson is at the beginning of the deportation process, and then this sentence. His removal could not be realistically expected to be effected in the near future. Then there's a reference to the Ugandan expired passport on file. 2 days later, on the 29th of January 2014, the respondent wrote and informed the appellant that based on his parents' nationality, he was deemed to be a national of Uganda. And you can see that in the supplementary bundle, sorry to jump between the two bundles, but chronologically I think it's consistent. Page 91. Supplementary bundle. You see that, it's the 29th of January 2014, and it's the second last paragraph. Your parents are Ugandan nationals, neither was settled in the UK at the time of your birth. neither yourself or your parents have been granted settlement in the UK. Therefore, you retain the same nationality as your parents and are a national of Uganda.
We could read the first paragraph too. He claimed that he was British, actually. He claimed to have been born in the United Kingdom, but whatever the position of his place of birth, that wouldn't make him British.
That's right.
The reasons given at the end.
Exactly, yes. It's absolutely right that until later, and this may form a significant matter to be discussed, that the question of his statelessness, which comes later, of course, was not how it's presented previously, and that he maintained he was a British citizen, and certainly we can see in the judgment of Mr. Justice Sweeney, and of course, importantly, earlier on in relation to the hearing in the Immigration Tribunal, the question is a different question, but it's a question of whether he's a British national or not. Absolutely right, my lord. The question of statelessness doesn't appear at this stage at all. Of course, that's accepted. But no, my lord is absolutely right that he claimed he was British on the basis of his birth, and of course we don't advance any arguments simply because you're born in the UK. Does that give you a right to be a British citizen? On the 7th of February, I'm turning to the key documents. On the 4th of February, before we come to the 7th, the 4th of February 2014, there's an auto-deport minute completed by the respondent. I think it's the same person who completed the entry on the 9th of January 2014. And it's at 358 to 362 of the core bundle. Must be the same Mr. Peterson. You can see that from the bottom of 362. And this auto-deport minute includes at 360, third paragraph, checks have been carried out, checks with Intel which confirm that there is a corresponding entry relating to the birth certificate. Information has also been requested from Central Middlesex Hospital Records Department, who have confirmed by phone that birth was registered at the hospital. Rest was requests made for written confirmation, but no reply had been received. And that, of course, is consistent with the document at supplementary bundle, page 84, the birth certificate document has been taken into account. On the 7th of February 2014, the appellant was served with a decision notice to make a deportation order against him under section 32(5) of the UK Borders Act 2007. And you can see that at 377 and 386. The covering letter is dated the 7th of February, but it does look like the decision notice was actually served on the 19th of February. So 377 is the date of the letter, 7th of February, and making confirmation that it's the decision has been made under section 32(5) of the UK Borders Act. But the reason we think it's probably the 19th of February is that you can see the on 386, the date of the 19th of February 2014 appears to be the actual decision, which starts at 379 at 386. On the 17th of February 2014, looking at this document, the deportation order was signed and subsequently served on the appellant, along with a notice of decision, and confirming that section 32(5) of the UK Borders Act 2007 applies. It was accepted by the learned judge that first, the appellant was considered to be subject to the automatic deportation regime under section 32 of the 2007 Act, and that the basis upon which the respondent considered to him not to be so was not merely that the appellant was not British, but that he was, as a matter of fact, a national of Uganda. And we can find that at page 146 of the judgment, at paragraph 24.
146.
Page 146, paragraph 24 of the judgment of Mr. Justice Sweeney, as it was. My lords, my lady, will see there's a reference to section 32, and then in the middle of paragraph 24, the reasons, including a presumption in the claimant's favour that he was born in the Central Middlesex Hospital, but still concluded that the reasons summarised in the defence letter dated 29th of January 2014, see paragraph 22 above, that the claimant was a Ugandan citizen.
Can we just check what is Mr. Justice Sweeney referring to there? He must be referring to a document of the 17th of, or a minute of a decision of the 17th. Of 2014.
17th of February document is, I think, the one that I've just taken you to.
Which was that?
That's at 379 to 386 of the main bundle. There's also, I think, a reference to the supplementary bundle, the 110. Yes, supplementary bundle, page 110.
And where in the actual document does it say we are deporting you because you are Ugandan, as well as because you're not British? It's a long document, just to save us reading.
It's at 383. It is a long document. We'll go briefly to the supplementary bundle as well. I think that helps in terms of explaining the
Just
situation.
read the paragraph first, please. In this document that you say says we are deporting him because he's section 32 applies because he's Ugandan.
Yes, it's 44 and 45. Could you see, please, at page 383, paragraphs 44 and 45. You claim you're a British citizen, and so on, as explained in the letter on the 29th of January 2014 that we've gone to, under the British National Act, any child born in the UK not automatically a British citizen. As your mother is Ugandan and has been given only clearance to enter the UK as a visitor at the time of your birth, your nationality is that of Uganda in common with your siblings and mother. Further to which, your mother submitted a Ugandan passport in your name, which gives your place of where Uganda, which conflicts with your British passport. On this point, you're given the benefit of the doubt, as demonstrated in the paragraph above. A place of birth, the 24th of December 1989, does not affect your nationality. I think it's actually affect with an A, but it doesn't matter. As to have been born in Uganda on that date, or to be born in the UK, would result in you being a national of Uganda. So I hope, my lord, that clarifies that point. If you then go to the supplementary bundle, at page 110, we there have the deportation order.
Sorry, just repeat that. That's SB 110. Thank you.
Sorry, yes, my lady.
Documents do seem to be distributed at random between the two bundles.
My lord, I can only apologise.
I'm sure you're not responsible for that.
I'm not.
It makes
It is
handling
unfortunate to have to jump about between bundles, and I'm sorry.
It seems odd because normally we take the facts from the judgment below, and you're not suggesting that any of these facts are found wrongly or that are misrepresented. I understand your arguments about failure to give weight to certain facts, so it's unclear why we need to go through the exercise that Mr. Justice Sweeney did. That's what the first instance
My lord, I take responsibility for that. I formed the view that it actually will be helpful to go to the documents in terms of the chronology, because when it comes to legal submissions, I think they make more sense when one has seen the history of the matter. So, my lord, I of course accept that.
You carry on, Mr. Mentor, but on my lord's question, are there in fact any primary findings of fact by the judge with which you quarrel? He sets out the history in enormous detail. I appreciate that there are, as it were, what might be described as value judgments by him as to what's a reasonable period, or whether the Secretary of State's officials could reasonably be expected to know X or Y or Z. But in terms of findings of primary fact, this happened, this happened, this happened, are there any that he got wrong?
There is one matter, but generally not.
Which of the one might be useful to know now? Which paragraph of the judgment is factually wrong?
Well, it's really about, well, it may be that I can circumvent that by, when I come to my submissions, I will say that what it's really about, it's more about the learned judges' analysis and interpretation, and makes factual findings on the basis of his assessment of the evidence as opposed to the primary facts. Does that help? Because I will come to the question.
Not really. If there's one primary fact, by all means get a prompt from Dr. Wilcox.
Yes. The primary facts are not in dispute, but the question of the reasonableness of the basis by which the learned judge got to a finding that he was a Ugandan national is open to challenge.
All right.
So it's really an analysis as opposed to primary factual finding. Thank you. So I'm just briefly going to show you page 110 of the supplement, which is the actual deportation order.
Yes.
You'll see 17th of February 2014, and there's a reference to the appellant being a foreign criminal as defined by section 32(1). Importantly, because we will come back to that, there's a reference to other aspects of section 32 of the 2007 Act in that deportation order.
Which bits? Just give us a hint. This is useful to know rather than to be left in suspense.
Yes, what we say is when one comes to what happened the following December, in December 2014, the respondent applied section 34(4), which we shall come to, which is a withdrawal of the deportation order, and we are looking.
It's a revocation.
Revocation. That's correct. Yes. Revocation, and so therefore one has to look at section 32 and section 34 in that context. But section 32 is clearly relied upon by the respondent in the deportation order of the 17th of February 2014. There is a reference, and I think we do need to go to this. I'm sorry, I am jumping about a bit, and I accept that. Having gone to the judgment in relation to paragraph 24, there was a concession made by Sharon Buckle, who gave evidence, that the essential basis upon which the deportation order, which we've just gone to, made, was that the appellant is a Ugandan national, and you can see that in the supplementary bundle. I think she makes it twice at page 11.
And it's referred to in the judgment, isn't it?
It is, so perhaps we don't need to go there. Perhaps I can just ask you to note the supplementary bundle at page 11 and 14, 11 F to G, 14 E to F, that what Ms. Buckle, or Mrs. Buckle, said when asked questions about that in relation to why the deportation order was made. On the 26th of March 2014, an email came from the respondent highlighting the difficulties of securing Ugandan citizenship for an individual post when they're over the age of 18, and that's the supplementary bundle at page 376.
And that's dealt with in paragraph 27 of the judgment, yeah.
Sorry, my lord.
And that's in paragraph 27.
Yes, it is mentioned there, exactly. But this is the source document at page 376 in relation to what happens when the Ugandan national reaches. The Ugandan nationals explain that the subject would not classify as a Ugandan national as upon reaching the age of 18 he is required to apply for Ugandan citizenship. Length of time spent in the UK, a very important factor, etc., etc. And then it goes on a bit further. Regardless of the above, the Ugandan High Commission will not issue any ETDs unless the following information accompanies any ETD application, both new or outstanding. previous UK citizen, criminal history, length of time spent in the UK. Unfortunately, due to data processing, we're unable to provide such information at this time, and therefore this has led to an ETD process being paused. Our country pages on Horizon are currently being updated to reflect this.
So this is about a different Ugandan national. It's not about this claimant, this appellant.
No.
And they don't, according to this email, which refers to what a Ugandan official has said to them, presumably from the Ugandan High Commission, they must reapply at age 18.
Yes, that's exactly. We're not saying it has anything directly related to the appellant. It's reflective of the difficulties of securing Ugandan citizenship.
And applications are apparently considered on a case-by-case basis.
Yes, exactly. The following day, again, it relates to another Ugandan case. One will see, and it's 27th of March, an email from another representative for the respondent, another Ugandan case, and it's at 374 to 375, so just before, making reference to where the individual is characterised as in danger of being stateless. And you'll see that bottom of 374 starts. We're having similar issues with another Ugandan case as to those in a case who wants to return to Uganda. Ugandan authorities are claiming he's no longer registered for citizenship. And it makes reference to Ugandan legislation. And then at the bottom, there's a reference there to clearly not willing to issue any kind of document. We have a copy of his birth certificate, father's passport. They've contacted the Ugandan High Commission to little effect. He appears in danger of being stateless. You see that towards the bottom of 375.
Sorry, this seems to be talking about deprivation of citizenship.
Yes, it is a deprivation case, but so we're not saying it's exactly on all fours. We're simply submitting that this is a recognition that of the difficulties of Uganda and of the risks of when one is seeking to claim registration or naturalisation in Uganda. There's a danger of being stateless. So
it's my fault. This refers to a Ugandan case.
yes.
And then the material, and we don't have the facts of that, the material that's there to support it is section 10, and section 10.1 says, subject to the provisions of this section, the minister may, I think that must be by order, deprive of his citizenship any citizen of Uganda who is such by registration. And that's like what happens in the United Kingdom. We can't take away citizenship from people who had it at birth, but if they've acquired it later, we can remove it. If they've been registered, we can remove it. So this seems to be concerned with people who acquired it by registration and subsequently there's a decision of the minister to remove it. That's not this case.
It's not this case at all, but the only significance is that there's an understanding of the, if I can call it limbo land, of there are circumstances which statelessness may rear its head where, depending on the response in Uganda, to applications or deprivation, as my lord correctly observes.
What it says is this person is in danger of being stateless, and that's because presumably he's had his nationality by registration revoked, as far as we can tell from that email.
We're not overstating the point. We're simply alerting that it's open. There are circumstances in which statelessness may accrue by a country choosing to deprive or not accept someone's citizenship.
To deprive, it doesn't indeed not accept. We've gone through that. Yes.
I hope I'm trying to by the order we're doing things. I'm hoping we get to the submission shortly. So just bear with me a little longer, please.
Yes, that's all right. That's fine.
Thank you.
Where you're referring us to an email or other document about another case,
Yes.
can you, at least for my benefit, flag up this
Of course,
is not
I
about
thought
the
I did
appellant?
say another case, but of course, my lord, yes.
Right.
So we're returning now to the appellant's case, I'm pleased to say.
Yes.
On the 11th of June 2014, there appears to have been an agreement by the Ugandan High Commission that the appellant could be removed on an EU letter. That's at the supplementary bundle 147. Opio. You see at the top of the page, 11th of June, thanks for contacting the mission about removal of the appellant on an EU letter. The mission has no objection to the request. It would be appreciated if you had a look at the physical passport as the details of the biodata page look suspect. This is because it's an old passport. And it's right to say that the bio form sent was incomplete and stated the appellant was born in Rweri. And there's no mention, of course, of the UK birth certificate.
Can you just show me, please, the document that you say is the biodata? I think I know what it is.
Yes.
And then can you show us, please, why you say it's incomplete, i.e. that there is something not completed which should have been completed?
Yes. A specimen full biodata form is now, I think, at the back of the supplementary bundle. I just want to check you have that. 581.
And how do we know that this is the biodata that we're talking about? Oh, because it's headed biodata information.
But I'm sorry, I haven't got it.
Right at the back of the supplementary bundle.
It was ever thus. My bundle runs out at 578.
So that you have this is the full biodata information. We're going to take you to what was actually supplied shortly, but you'll see there. So you can see the full biodata information suggests there that nationality is Ugandan, date of birth is there, place of birth Rweri, that's at 581.
But that's place of birth of the mother, isn't it?
No, I think at the top of the page 581, my lady, family name Masazera, other names Aldu Johnson, date of birth. You're quite right. There's no answer on the place of birth.
No.
On that.
And the one that we've got below, Rweri, Uganda, is mother's.
That's exactly right, my lady. Yes. There's the answer to my Lord Justice Lewis's question in terms of what was supplied. It's in the supplement. So this is the full document. The document that was supplied is at 145 of the supplementary bundle.
We've just been provided with a 2-page document, which you say is the full one. I don't have any idea at the moment as to when this was completed, why it was completed, why you call this the full one, what date it came into being, or anything. It's not signed or anything. What is this document?
We understand this full document was disclosed by the respondent in the hearing, prior to the hearing, beginning.
And you call it the full document as if that has some significance. What you're saying is that there's a 3-page document, not signed, not completed, which was disclosed. So that's the factual position.
That's the factual position, yes. What we have in relation to the document that was provided back in 2014 is, I think, the supplementary bundle at 145. 146.
And that differs in that it gives place of birth Rweri.
Yes. It's an incomplete document, it's unsigned. But as my lady correctly observes, it differs from the full document.
Well, let's not call it full and non-full. The disclosed document and the document that was provided differ. Yeah.
Oh, yes. One would have expected that a document as important as these, both the copy of the passport and the biodata information, to be signed or to be something there to show it had been checked properly and authenticated, and there's nothing. And it clearly contains a material error.
So was 145 and 146 the thing that was actually sent and to which the 11th of June letter responded?
Yes, and there's no mention of the UK birth certificate. On the 25th of September 2014, there's a minute of an official level meeting at the Ugandan High Commission. That was served on the day before the trial, I'm told. Supplementary bundle 451 to 454.
Your speaking note or chronology, or whatever one calls it, today gives quite a substantial extract from that. Do you want any more than the extract?
No, I think there's no need to. I'm happy to go a little bit faster because you have that document.
Yeah.
It's just, as my lord and lady see, there are some aspects that do need a little bit of development because there seems to be inconsistencies and lack of clarity at certain stages. But the section that we quoted at supplementary bundle 451 is sufficient. Thank you.
Yeah.
On the 18th of October 2014, I don't think we need to go to that, but we have at the moment, first tier tribunal Judge Wiseman promulgates a decision refusing the appellant's appeal against deportation, and we've cited the section. I don't think I need to go to that now. Now we come to a crucial period later in 2014. On the 8th and 9th, the night of the 8th and 9th December, a day of 8th and 9th December, there's a GCDI note. This expired passport had apparently been couriered to the Ugandan High Commission. It is clear from the note it was deliberately sent without the appellant's birth certificate, which was sent separately to the removals team. And you can see that at the supplementary bundle at 584. This is important because the 9th of December 2014 was a significant day. So 584, right at the back of the supplementary bundle, you can see there on the minute case notes on the GCID case record sheet, 8th of December, expired passport courier to the mission for revalidation. 9th of December 2014, courier to collect passport from the mission and transport to Heathrow for removal, birth certificate 2 to be couriered. So it looks like the birth certificate was being sent separately. The 9th of December, significant.
I'm sorry, but you said was deliberately sent separately. I mean, all that shows it was sent separately. It doesn't show any deliberation of any
Well,
kind.
perhaps I should have said, I agree, deliberately overstates it. It's not pejorative. What is clear is that they were sent separately.
They were sent separately.
They were not planned to be sent together.
My understanding is the passport was with the High Commission and the birth certificate, the authenticity of which had still not been confirmed in writing, was in the Home Office. So they were in different places.
Yes.
So that's completely why they were sent separately.
Yes.
I suppose they could have said, courier must take passport, must stop off at Luna House, must collect birth certificate and ensure that both are sent together. But it doesn't say that.
That's very well put, my lord. That's certainly not taking a point on that anyone suggested this was done to confuse anyone. It is clearly
It happened.
it was a practical situation.
Yes.
It happened, yes. On the 9th of December 2000...
Sorry to interrupt, Mr. Metz. I'm going to ask my judicial assistant to go to my clerk and see if I can be supplied with copies of pages 579 to the end, because they seem to be among the most referred to pages, and I haven't got them.
Oh, I'm very sorry, my lord.
That's all right. No,
Is it just your...
I expect they were sent by an email or something, but anyway, we're looking at them again and again and again. And
I'm really sorry. We can get you another copy, but if...
Well,
It's 579 to 587.
right.
Thank you. It's ironic because I think I can carry on because the next
Yes,
document
of course.
doesn't deal with that part. So on the 9th of December 2014, there was an attempted removal of the appellant to Uganda. At Entebbe Airport, he produces his birth certificate to the Ugandan authorities, his British birth certificate, birth certificate of showing he'd been born in the UK, to the Ugandan authorities, and was refused entry. And as a consequence, he's returned to the United Kingdom. The following day, on the 10th of December, there's a note in relation to what happened on the 9th of December, and you need to please see that at the supplementary
Can I
bundle.
just check one thing?
Yes.
Did the Ugandan High Commission produce a document, stamp a document, send an email prior to him leaving the airport at Heathrow saying they were satisfied with what they had got, or saying that they thought everything was okay? Or is there just silence from the Ugandan High Commission?
My lord, I don't think I can answer that. We know the EU letter disappeared, has been destroyed, we understand.
And the European Union letter, because I'm not familiar, I haven't seen one for a while, what would that have said and how would it have come into existence? Would it have been seen and approved by the Ugandan High Commission?
The reference to the EU letter I've taken you to earlier that looks like the Ugandan authorities would have been prepared to consider it. We simply don't know.
Do we have a specimen?
This was one of the issues that was explored. I think that did come up in the trial, actually. Can I come back to that? It may be that my learned friend can assist in that too. On the 10th of December, can we go please to supplementary bundle 213? This is a GCID note of the following day, and you'll see there in the middle of the page, despite the best efforts of TASCOR, FCO, Entebbe, and MBO and CROS, this sub has been refused entry by the Ugandan authorities. Drop down below the ABCD.
But it's important in the light of what we've just been discussing, what is said next. When I left yesterday evening, the High Commission in London had spoken to the UGA authorities and was supportive of our efforts to try and get Mr. M admitted. So that doesn't go as far as what we were talking about, but it's some indication of what was going on.
Yes, my lord, my lady, that's right. Only in the interest of time I was going to, but you're quite right.
And it goes on, as they had verified his passport as genuine.
And then, of course, it goes on to talk about immigration of the view,
Yeah.
and then A to D. But my lady, that's right. So that does give an indication as to the thinking around the 9th of December. And then it goes on to say it was not.
Yeah, there's so many things that we don't know about here. The Ugandan authorities, presumably somebody in Kampala, the immigration presumably is a reference to the actual immigration officer at Entebbe.
Yes.
And then it says it was the immigration officer's decision whether or not to admit them. They were unsure that the correct process had been followed in London. Their citizenship laws had changed so that the appellant may have lost his citizenship. He's been away an awfully long time, and the Ugandans don't want the United Kingdom to use Uganda as a dumping ground. That's all we know then.
Yes, that's right. And it goes on to say it was not helped by the fact that the appellant had a UK birth certificate, which he himself presented to immigration there, further muddying the waters. After many hours of deliberation, it seems the Ugandan authorities decided late last night to refuse him entry. So again, my lady, I think we get some assistance as to the difficulties that the Ugandans were presented with. So the following day...
And further down it says, Mr. M is compliant and delighted to be returning.
Yes.
Mistake, or is that correct?
I don't think we've got any, got no instructions to challenge that was his state of mind at the time. I think it was, if my lord means, was he pleased not to be in Uganda to be
return
returned?
to the United Kingdom,
Yeah.
not. I thought he meant return.
He didn't want to go to Uganda. No, I think it's very much the other way. He was relieved that he was able to return here. And there's really a repetition of the point at 217 I don't think we need to spend long on it, but the note really makes the same points at the top part of 217 and then confirms that he's on his way back. And then the following day, the 11th of December, he's re-detained under immigration.
I'm sorry, it might be relevant back to 213, the last paragraph. You will need to liaise with CROS, next steps retrying to get Mr. M accepted once we know the final decision for the reasons not to admit him. That may or may not be relevant. Anyway,
Yes,
I'm sorry I
I'm
interrupted
grateful.
you.
No, not at all, my lady, that is helpful. I'm not sure the point ever gets answered, but I think it's a relevant point to have raised. Then we have, as I say, I don't think I need to spend long with it, the reference at 217 as well from Claire Duncan dealing with removals planning, really citing the same section at the top. The following day, the appellant, that's the 11th of December 2014, is re-detained on immigration powers upon return. On the 19th of January 2015, as a detention review, because we now have an impasse between the British and the Ugandan authorities on enforced return because of the disputed nationality, and there's a reference to expert legal advice being required, and you can see that at 2266 to 272 of the supplementary bundle. You'll note at the top of 266 he's still described as Ugandan top on the note. And the relevant section to look at, please, is 272. I'm not going to ask you to spend long on it, except to see that the reviewing, bottom of 271, really repeats what we've already looked at, but makes a reference there to a formal legal position could be procured from counsel to assist this, looking for legal advice. And then
See, where are you?
271, my lord, the
You're
bottom.
going to start at 269, which is assessment of removability. And paragraph 7 says the whole file and so on. The reason given have been raised with an acronym, and in view of the evidence available and support of the Ugandan High Commission, it is still seen that removal can be achieved in a reasonable period. So there's paragraph 7 of 269, and you want us to look at 271?
Yes, please, my lord.
Yeah.
The bottom, last paragraph. Deals what happened on 9th of December. Reference to forthcoming discussion. The formal legal position could be procured from counsel to assist this. The issue of loss of Ugandan citizenship affects a number of cases currently being processed. I consider the absconding reoffending risk to be sufficient to outweigh the presumption of liberty. Authority to detain is given. And then at 272, comments, authorising officers' comments. Mr. Mazzaro, the appellant has considered to pose a risk of harm of absconding, removed in December, returned despite having a valid passport which had been verified by the Ugandan authorities due to issues around citizenship. I've raised the wider issue with CROS and with the FCO and await a response on how we will break this is why I described it as a current impasse with the Ugandans. Whilst I acknowledge this may cause some delay to removal, detention remains appropriate as we can expect movement on the issue in the near future. And that's consistent really with my lords had taken up with the court to 269, that it was considered that on that date that removal was the removal period would be a reasonable period on that. In other words, an anticipation that the impasse might be broken. On the 16th, I don't know if I need to take you to it, I'm just going to ask you to note, on the 16th of February 2015, the detention review, Sharon Buckle, who gave evidence, as you know, we say she evidenced a deeply counterintuitive confidence that the document held for the appellant is genuine and will be sufficient to effect removal swiftly. Of course, I accept that is a submission. If the court wishes to go to it, that's fine, but that's what she said.
Page reference, please.
The page, it's two places. It's in the supplementary bundle at 281, but it's also her evidence, which you can go to as well. It's the document is 275 to 281. 281, my lord, can see under the authorising officer's comments, Sharon Buckle, negotiations are ongoing with the Ugandan authorities and we are hopeful of progress shortly. We are content that the documentation we hold is genuine and that removal can be effected swiftly, and then gets a 28-day. And there's, I'm not, unless the court wants me to, I wasn't going to take you to the judgment, but there's a reference to that, to 218 of the main bundle. Paragraph 218 at page 211. On the 3rd of March 2015, this is one I do need to take you to, a GCID record dated noting that removals for Uganda are on pause, and that I'm not going, unless my lords and lady wish me to, I'm not going to go to the document. I'm simply going to refer you to the judgment at page 162.
Well, can you give us at least the reference? Because
Yes, of course. It's at page 585 of the main bundle. Sorry, there's no, just trying to check. Supplementary bundle 585. And it's in the quoted at paragraph 83 of the judgment at 162. The court can look at briefly. That's 162 of the main bundle, core bundle. GCID record dated 3rd of March 2015 confirms removal on pause. Removal talks were taking place that week, and CROS had agreed to inquire about this case in particular. On the 11th of March 2015, a further detention review stated that the only barrier to the appellant's removal was the securing of an ETD. We've put that in our key documents. I don't propose to take you to that, but for your reference, it's supplementary bundle at page 290. It's right to say that at that time, there was a requirement in securing such an ETD to submit the appellant's full UK birth certificate. And with that, I think we should go to at 4.5.
You've lost me completely now. I was looking at the 3rd of March because you took me to paragraph 83. I'm afraid I then started reading paragraph 86 because there's another review on the 11th of March, and that.
Yes, that's what I'm coming to.
That's what you're coming to, is it right? Okay.
The 11th of March review and the 16th of March minute and the 13th of April review are all quoted from at
They are. They're all in the
considerable
judgment.
length by the judge.
They're all they're all absolutely.
Yeah.
The only thing and I don't think we need to go to that. The only thing I think will be helpful to take you to is the operational instruction in relation to the requirement to secure an ETD of the UK birth certificate. That's supplementary bundle 457.
Yes.
That's an interim operational instruction of March 2015. And you'll see there the minimum requirements for submission are, and you'll see the 4th one down makes reference to birth certificate. So that had to be supplied, a full UK birth certificate.
From
Otherwise,
March 2015 onwards under this letter, yes.
Yeah.
And the maiden application, did they provide the full UK birth certificate?
I thought it had been provided to the people at Entebbe Airport.
But did they, to be absolutely crossing the T's and dotting the I's, Mr. Metzer is saying this document in March 2015 says that the birth certificate must be provided, the UK birth certificate, and we know an ETD was sent in or around March, April, and I'm just checking.
I don't think we know the answer to that.
But you don't know that it wasn't provided, so
I
you don't
can't
know
say,
whether the
can't say
operating
one way or the other.
instruction was
It's clearly it has to be supplied. Whether it in fact was done, we don't
for
know.
March 2015. So when they made the ETD application in March 2015, they would have to have included the birth certificate, but it's not part of your case, and you haven't got evidence about whether or not the birth certificate was or wasn't
In fact,
supplied in March
not.
2015.
That's exactly right, my lord. On the 13th of April, we've gone to that in the judgment. I don't need to come back to that, but there's a recognition, and it's really in the supplementary bundle at 292 to 299. on the detention review of 13th of April, which, as my lord rightly observed, and I don't need to go, is expressly referred to in the judgment, but at 298, anything I need to ask you to look at, please. Towards the bottom of 298, authorising officers' comments, including a response to recommendations, a barrier to removal is the absence of an ETD. VR is confusing in the position with the Ugandan authorities. Can we update to reflect the current position? This is a difficult case which hinges on the consideration of the Ugandan authorities who have RLE'd him in response to our attempted removal on an expired passport. So there's recognition within the detention review that it was a difficult case.
Yeah.
On the 18th of June 2015, the appellant is finally released on tagging and reporting conditions after 6 months after the attempted removal, so December 14 to June 15. A year later, on the 9th of June 2016, there's a leave to remain application made by the appellant as a stateless person, subsequently refused, and you'll see that in the core bundle at 395.
Well, from this point onwards, the text of the documents is less important.
I agree.
Yes, all right.
So that is the reference to it. 11th of February 2019, nationality status application. We know that his application to be stateless was refused. The respondent decided to reconsider the application on the 2nd of July, refused the statelessness leave on the 20th of November 2019. From my lords and my ladies' notes, that's at 394 to 400 specifically. And this is perhaps we do need to go to, and I'm nearly at the end of it, I promise you. At 399. So we now have, of course, in November 2019, 20th of November 2019, can I ask you, sorry, I probably should have taken you first to the bottom of 397.
Well, you need to go to the two paragraphs that is considered that whilst the applicant appears to be compliant to Ugandan citizenship, and has included the passport in the past, it's clear that Uganda was a now refusing to accept.
Yes.
And then
So, my lord, where are you?
297.
Yes. Yes, exactly. I'm happy to go there. Yeah, that paragraph. Consider that whilst the applicant appears to meet requirements for citizenship as being issued a passport, is clear the Ugandans now refusing to accept him as a national. Then there's a reference to advice being sought, and at the bottom, the applicants made all possible attempts to various nationalities, complied with the Home Office, attending interviews with the Ugandan High Commission. Is also provided evidence which, where possible, to verify his nationality, birthplace. Based on the above information, it is accepted that the applicant is stateless, as it is clear that he will not be accepted by the Ugandan authorities as a Ugandan national. The applicant has met the requirements of paragraph 403, and at the bottom of, and then there's a reference there to, after 403, he meets the requirements of 403, as such as accepted, he's stateless under paragraph 404A. And at the bottom of 399, conclusion, a letter will be issued to the applicant explaining he now has been accepted as stateless under paragraph 403, but has been refused under paragraph 3225 in line with paragraph 404C. And we'll come to the law shortly.
Yes.
And on the within a week, 26th of November, this is the last, I think the last, almost the last date, 26th of November 2019, the respondent considered revocation of the deportation order and did decide to revoke, and we have that at 389 to 393, so just a few pages earlier in the bundle. And at 390, there's a reference there. In the middle of the page on 390, in light of the narrative of refused acceptance on return, refused by the consular services, going to enter any further approaches, SRO of the view that recently augmented guidance is applicable to this case. It is the position of the national authorities rather than the letter of the law that's likely to be decisive in concluding that the state does not consider such an individual as a national. Our efforts to have the Ugandan authorities accept a notional entitlement to nationality have failed. In practice, they will not accept or document as Ugandan national no entitlement to any other nationality. Then there's a reference to Schedule 3 of the Immigration Act 1971, in which it makes reference at the end part. There are no workable options in respect of the appellant, and as such, the deportation order cannot be enforced and serves no purpose. Substantive SRU decision will be served with our warning letter. And then on the back of that, on the 12th of December 2019, the appellant's deportation order is revoked. And so you can see that it's first of all mentioned at 355 to 356. We don't need to go to that perhaps, but at 393, just 2 pages further on, you can see there, request recommended action, you please consider revoking the deportation as it cannot be enforced and serves no purpose. And then in the box below, in pursuance of the power conferred upon them under, and this is where I said we're going to have reference to section 34(4) of the UK Borders Act 2007, the Secretary of State hereby revokes this deportation order. So the revocations affected under section 34(4), clearly we respectfully submit this indicates the respondents no longer of the view that the appellant falls within the ambit of automatic deportation regime under section 32(5) because of the withdrawal of the decision. So that really is the background narrative. I know it's taken some time, but I hope it will be of help.
Yes.
In relation to turning now to the law, which I hope to do very shortly, I don't think this is controversial. We deal with the law of unlawful detention. I don't think I need to trouble the court with that. It's all settled law, public law, similarly. The deportation aspects, the statutory framework, we've cited section 35A of the Immigration Act 1971. I'm happy to go to that, but again, I think it's clear its relevance. You can find in the authorities bundle, section 35A is at page 2 of the authorities bundle. Section 5, if perhaps we should just briefly go to section 5. That's at page 6.
You've got this in the skeleton argument.
I have. My
Native.
lord, if the court is content, I shan't.
Yes.
Certainly. Just for your reference, section 32 is at page 16 of the authorities bundle, and the footnote, section 33, is at pages 19 to 20. And turning the page in our skeleton, page under paragraph 9D, section 34(4) that we've just seen reference to, you can find that at page 22. And we say there's clearly a power to withdraw an initial decision, which amounts to an acceptance of the basis for making of a deportation order no longer applies. As far as detention pursuant to an unlawful deportation order is concerned, we cite DN Rwanda again, unless the court feels differently. I don't think I need to go to that, but the page references in the authorities bundles are 229 to 230. Hardy-Singh, I know, is very familiar to the court in relation to the 4 Hardy-Singh principles. They are well cited in Lumba. Again, unless the court wants me to, I don't think I need to go to those now. They're very familiar to the court. There are pages 119 to 120 of the authorities bundle, setting out the 4 principles. HXA, at page 7 of the skeleton, paragraph 42, can be found that there's a reference. The case starts at the authorities bundle, page 42. I don't think it's controversial, and if necessary, I can take the court through that, but I don't think I'm going to trouble you further. And then we have the reference in Lumber, Lord Dyson's 8 criteria, but citing his own judgment. That's at Lumber, page paragraph 104, page 140. Would it be of any assistance to go to that? Can I take that as read? I'm very happy to go to.
Well, by all means,
Perhaps it's an important point.
Let's have a look at that.
Perhaps we should have a brief look at that. That's at in the authorities bundle at page 140. Lord Dyson looks at, he cites his own judgment in I, at paragraph 102, and then at paragraph 104, he provides a list of the main factors. He quotes his own judgment in paragraph 48 in I and says it's not possible or desirable to produce an exhaustive list of all the circumstances that are or may be relevant to the question of how long it is reasonable for the Secretary of State to detain a person pending deportation under Schedule 3. But in my view, they include at least, and then he cites these, the length of the period of detention, the nature of the obstacles which stand in the path of the Secretary of State preventing a deportation, the diligence, speed and effectiveness of the steps taken by the Secretary of State to surmount such obstacles, the conditions in which the detained person is being kept, the effect of detention on him and his family, the risk that he is released from detention and will abscond, and the danger that if released, he will commit further offences. Statelessness, the relevant rules in relation to statelessness is Rule 401. I think we can find it as stated. There is also a copy. Yes, we have. It may be helpful. We can find it stated at of the core bundle at 439. But it may be of it may be helpful if we just hand up the actual rule itself.
You cited a skeleton argument, paragraph 18.
Yes.
If you need more context, then let's have it.
Yes, I think when one looks at the when one looks at the rule itself, which I've now handed up, I hope it will speak for itself, but I'm very happy to help the court.
Is this the same as on page 439?
It is, but it's the actual document which it's a little bit easier to read from. But yes, the significance of this is what the definition of a stateless person is. Now, for the present purposes, and it's perhaps self-evident, but it is important to just spend a moment on it, please. At A, it's a person who's not considered as a national by any state other than under the operation of its law. The person is in the United Kingdom, and C, is not excluded from recognition as a stateless person under paragraph 402. And then there's examples of exclusion, none of which were applicable in the present case. And then there's a reference to paragraph 404. An applicant will be refused leave to remain a stateless person if their application falls to be refused under any of the grounds in paragraph 322. And we've seen reference to paragraph 322 already in the documents that we've looked at.
Before you leave 401, as a person who's not considered as a national by any state under the operation of its law,
Yes.
part of the problem here is there seems to have been, as far as we can see, two references to bits of Ugandan law. That would be a question of fact if it's foreign law, and there would have to be expert evidence. The Constitution refers to somebody whose parent is a Ugandan national, wherever they are born, and you've shown us an email which has section 10 of some Ugandan act, which says you can revoke deportation acquired, nationality acquired by registration. We've seen emails saying the law may have changed, but we don't know when. And we've seen references to maybe you lose it at 18, maybe you can reacquire it, maybe dependent on other things. But we don't actually know whether, as a matter of Ugandan law, he has ceased to be Ugandan by virtue of Ugandan law. We don't know when that occurred or whether he could reacquire Ugandan nationality, do we? Because we haven't got any expert evidence to tell us what the Ugandan law is.
That's exactly right. What we do know is that it's clear the Ugandans rejected him.
Yes, many countries do. There are some countries who set very high hurdles because they don't want their own nationals back. That is very difficult for people to prove. one country that I won't name, that requires a certain number of sworn witness statements for the village where the person was born. It's very difficult, and it's not in the interest of that person to get it.
Yes.
So they end up being regarded as stateless, even though we don't know whether under the law of that country they would be stateless. But anyway, you agree that we don't know whether he's Ugandan or not, if he's not when he lost it, and whether he can require it.
Because it has now been accepted.
We're looking at 2014-15, aren't we?
Yeah. The history, I think my lord must be right. We don't know what happened internally in Uganda. What we do know is that he becomes recognised by the respondent as being stateless.
Yeah. In 2019.
Yes, December 2019. And now looking at paragraph 19 of our skeleton, we've just gone to paragraph 404C, in reference to paragraph 322 of the immigration rules. The respondent has a policy, statelessness leave, which was the relevant one at the time, coming into effect on the 30th of October 2019. And it's at the authorities bundle at 283. Sorry. My mistake, 270.
So this is the Home Office document on stateless leave.
Yes, my lady, and it's the one that was relevant because it came into effect on the 30th of October 2019, and it's at page 24 of the document. Page 24 is to be found at 293. General grounds for refusal set out after paragraph 322. This I've cited in our skeleton, paragraph 322, part 9. Can I just please take the court to the last part of that paragraph at 293? This is because those refused under general grounds who are stateless and not admissible to any other country cannot be removed, because there is nowhere to remove them to, and as such may fall for a grant of leave outside the immigration rules. So we respectfully submit that there's a clear recognition of the fact that the person can be stateless without qualifying for leave to remain as a stateless person under the immigration rules. So the policy in place at the time permits grant of leave outside the immigration rules for stateless persons. So we respectfully submit that their inability to so qualify does not impact upon their underlying status as statelessness. So they're still stateless. They still have a statelessness status, even though they do not qualify for leave to remain as a stateless person. It is right to say, we put this in our footnote 12, perhaps of some interest, it is noteworthy that these provisions on statelessness and the immigration rules only deal with the granting of leave to a person determined to be stateless. They understandably do not provide for a situation such as that the appellant found himself in, namely that as a stateless person who, since he was born in the United Kingdom, was and always had been present lawfully, but without leave. It's an unusual situation.
How was he present lawfully? He didn't have leave to be here.
Well,
He's never had leave to be here.
my lord, perhaps we do need to, because we say he did have lawful status. Can we take you to the case of Akinyemi in the authorities bundle?
Lawfully prior to the making of a deportation order.
He had no leave. He never had leave.
It wasn't controversial, but it's a proposition which has been held in Akinyemi.
Okay. I don't think it's in the authorities bundle, but the case.
Never had it afterwards. They applied
We can obviously get it for the court, but to deal with my lord's point, the case of Akinyemi, judgment of Lord Justice Underhill.
Where are we now?
We only have it at the moment in the footnote 12 in our skeleton. It's at page 9 of the footnote 12. We can get that authority. I don't think it's controversial, but it deals with my lord's point that you can, when you're here in this country, born here, but without leave, that's lawful.
Well, it's not unlawful.
I should be more accurate, not unlawful.
It's not lawful.
It's. I don't think I can firmly assert it's
By virtue of his mother's visitor's leave when he was born for 6 months. Thereafter, she was never granted leave for a long period of time, and his application for leave that he made was ultimately refused. So he's been refused leave under the immigration rules at every stage, and then he was granted leave, discretionary leave for 30 months, as I understand it, outside the rules, as an exercise of discretion on the part of the Secretary of State. Is that right? Or? No,
not completely, my lord. It may be necessary to go to Akinyemi. Certainly,
I don't want you invited. We can look it up if you haven't got it.
If you're born here, the leave regime is only leave to enter, leave to remain. If you're born here, you've never needed leave.
If you're born in the UK, it is a different regime from being granted leave to enter.
Okay.
So it is accurate to say that Akinyemi, Lord Justice Underhill makes clear that it is not unlawful to be in that situation. It is. I don't think we can firmly say that you get lawful status by it, but it is not unlawful.
Leave doesn't apply.
Because leave doesn't apply because you're.
Leave to enter doesn't apply because you're already here, but leave to remain certainly does.
Yes, if this becomes an important point, we'll have to look at Akinyemi, but I'm hoping we can move on.
He didn't enter the United Kingdom. He came here by act of God, almost literally.
Yes, well, he was born very young. That's right. Yeah, he was. Yeah, that was badly expressed, but Lord has the point. The duty to give reasons is self-evident. I don't think I need to spend long on that. I'm sure the court is very familiar with that material. And on delay, the citation is at Authorities Bundle 438 to 440. As I've said at the outset, we don't say delay alone gets us home, but there is reference, of course, in the case of Bilter, to delay being an important factor to take into account when the appellate court is considering the trial judge's findings and treatment of the evidence, and the appellate court must exercise special care in reviewing the evidence. The judge's treatment of the evidence, his finding of fact and his reasoning. The fact we had such a long delay could be relevant to underlying findings.
Yes.
And I say no more. I'm going to take you really now straight onto the grounds. As I've indicated, I'm not going to spend almost any time on ground 4 individually. On the 3 really substantive grounds, the main grounds, we first submit that the learned judge was wrong to hold the deportation order made under the automatic deportation regime under Section 32 was lawful and remained lawful throughout the entirety of immigration detention. Grounds 2 and 3 are both Hardil Singh grounds, first in relation to the first limb and then in relation to second and third limbs, and then we've made reference to the 4th ground. So the one perhaps the ground perhaps takes a little bit longer, although I think hopefully we've covered quite a lot of ground material, is the legality of the deportation order.
Yes.
Now, the learned judge's findings in relation to that can be found at pages 192 and 193. Paragraph 164, and it's cited in full, paragraph 164, pages 192 to 193. And importantly, since my lord asked earlier about concern about any underlying findings or factual findings, this is the point that is concerning the appellant. It's at 1644B at page 193. Against the background of my outline findings of fact above, he deals with a recognition stateless on de facto grounds, not de jure stateless, or that he became de jure stateless during the course of his detention, including those relied upon the defendant as recorded at paragraph 1621 above. And you can see that referring back, 1621 is page 189 to 191. There are 10, paragraph, 1621 is page 189. These are the points made by the respondent, 1A to F at 189, and then returning it, going back again to the findings. And the other findings, in fact, made below, when considering the remaining heads, he says, I find as facts that at more material times the defendant had a reasonable belief that the claimant was Ugandan, that he was removable as a matter of fact, and that in consequence he was subject to the automatic deportation provision. So that's the point in relation to a factual finding that we challenge in relation to the judge, namely that it was not a factual finding that he should, on the evidence, have reached in relation to the defendant's reasonable belief.
This was your alternative case below. So paragraph 1 and 2 deals with whether as a matter of law there is no exception for people who are said to be and recognised as such in 2019. And as I understand it, 1643, the claimant further submits that the defendant had to prove at all material times that he had a reasonable belief that the claimant was Ugandan. That sounds to me like an alternative way of putting it.
Yes.
That's what 164 goes to. And do you still put the alternative way of putting it then?
I think we do, don't we? Yeah, I think it is an alternative, my lord's right. It is very much a subsidiary alternative because the primary finding is a relation to whether he in fact was a Ugandan national at the relevant time, but the reasonable belief, so that if that succeeds, then we don't have to go on to the question about whether the status of the, if the status of the appellant was that he was not Ugandan or was stateless, then we don't have to go on. But there is also the question potentially in relation to the reasonable belief that he was Ugandan, even in fact, if, in other words, he either was, either defendant should have concluded he was stateless, respondent should conclude he was stateless, but if not, the alternative, whether there was a reasonable belief.
Isn't the first question whether there is an exception as a matter of law for people who are not British citizens but are stateless? If you lose on that, then nothing else matters, does it?
That is very much our primary case, and of course I accept that, my lord. I don't think we go quite as far to say you have to, that the, whether, I'm not sure we would say that that's wholly determinative, though it is very much our primary position. I don't think we, in other words, we say we abandon the alternative submission at 1643, but we absolutely, as a matter of law, our primary submission is in relation to the judge's finding as to which regime applied to a person who should have been deemed to be stateless.
Well, the starting point is, is he a foreign criminal? If was he a foreign criminal? If he wasn't a foreign criminal, you win, because it doesn't apply at all. I think you were going to start with that.
Yes.
And then you say, well, even if he was a foreign criminal, you say the deportation order was nevertheless unlawful because of the absence of a reasonable belief that he could be deported.
Yes,
Shall
we
we
start?
start?
We
shall
start on the foreign criminal.
Let's start with foreign criminal.
Absolutely. Thank you, my lord. So, what we say is that the learned judge erred in law in finding that the deportation order made against the appellant was either lawful and or remained lawful throughout the entirety of his immigration detention, because first, the learned judge was wrong to conclude that the automatic deportation regime applied to a stateless person who was irremovable, because as a matter of fact, at the time of the initial detention and various points thereafter, he was in fact irremovable. So we've got Section 5.1 of the 1971 Act, in which a deportation order is an order for an individual against whom it is made to leave the United Kingdom. If they our submission is, if they're simply incapable of being removed from the United Kingdom, the very purpose of the order is incapable of being realised. And therefore, we say a deportation order cannot be made against an individual who primarily is, alternatively, is reasonably believed to be irremovable by virtue of being stateless. In other words, there wouldn't be a regime in place which was futile, which was pointless, and if necessary, we would we could produce a material from various presumptions about absurd results not being intended. We can go to that if we need to. We essentially say,
You can reacquire nationality, question one. What if he can go to another state because he marries, for example, an EU national and goes with her to her member state as he would be entitled to? It may not be removable at the moment. There may be circumstances, because this is an act dealing with lots of cases, where individuals might become removable.
well, these are hypotheticals, but what we respectfully submit is if his status at the relevant time is statelessness, the fact that he potentially could acquire a status further down the line doesn't go to the point. It has to be assessed at the time in relation to whether the deportation order is applicable to somebody who is in fact at the relevant time stateless. So
And the relevant time
And
is
irremovable.
when the deportation order was made.
yes,
Okay, so at that date, if he is stateless, de jure, call it that, or if he ought to have been reasonably believed to be stateless at that time, the deportation order ought not to have been made, was of written water, of nothing, had no basis.
it was absurd, really, to use. I don't
What
mean
do you
that.
say?
Yes,
Yeah.
we don't use that pejoratively. We use it in a sense that they're not
Has
going to
no-
employ a regime which has no applicability.
Okay.
Um,
So
And-
we're looking at the situation in 2014.
yes, and thereafter, right through till 2019, I think.
Well, no, not for the deportation order. Either the deportation
Oh, the deportation order,
was
yes.
valid when it was
Yes,
made, or
I was
it
looking at the
wasn't valid.
unlawful. Yes, yes.
And if they can't give effect to it, then you've got your hard deal thing. But the question is, was it made? I mean, you've got two problems, haven't you? Firstly, you haven't got any evidence that on the 17th of February 2014 he had lost statelessness. We just don't know, because we know the law may have changed. The law we know, we don't know when or what. So you haven't proved that he was stateless. But the second thing, the deportation order doesn't just do that. It does other things. It invalidates, for example, any leave that a person has been granted. By virtue of 32(5), if he's a foreign criminal, his presence here is deemed not to be public good. That's a separate section.
If the regime applies, yes.
Yeah.
Yes, but
Yeah,
with
yeah,
great
possibly,
respect,
so-
that sort of slightly begs the question. So we're still back in a situation. Is it for an appellant to prove that they are stateless, or is it really about assessing the evidence properly in terms of what the learned judge should have concluded? We respectfully submit about his actual status of that.
The burden of proof is on the Secretary of State. If he can't prove that the person was actually not stateless on the 17th of February 2014, then he hasn't shown that the detention.
Yes, my lord has that right. We can take that a little bit further. That's why.
Two things must is deportation order can become unlawful. Secondly, statelessness is linked to irremovability. Statelessness is a declaratory when you recognise somebody. It's to recognise a status. Then you find that under the 1954 Act.
Really,
1954.
that's 3 points. I hope I remember them all. The third is actually answers your question.
Yes.
The position is that the statelessness is declaratory under the 1954 convention.
This is guidance.
Yeah, from the guidance. We can take that, my lord, to it's at page 284 of the authorities bundle. two other points I need to come back to, but this really, I hope, deals with this point specifically. This is the guidance in relation to statelessness. 283, I'm sorry, under the 1954 UN Stateless Convention. Does
Sorry, which bundle?
Authorities bundle, my lord. Sorry.
And this document again is the Home Office.
Yes, it's
And
guidance.
it's-
I think it's the same guidance I took you to for a different point. The
And it's
stateless
dated
youth guidance.
October 2019.
Yes, you can see that at page 270. 283, definition, statelessness of disability. Article 1.1 of the 1954 UN Stateless Convention defines a stateless person for the purposes of the convention as a person who is not considered as a national by any state under the operation of its law.
Yes.
An individual is a stateless person if the moment conditions in Article 1.1 are met. This means that any finding by a state that an individual satisfies that test is a declaratory act. So that's the point about it being
Declaratory from
declaratory.
when? Because he was, I thought the Ugandans, even the Ugandans accepted him. He was Ugandan up until he was 18. And we just don't know if this law did change or if it didn't change.
I don't think we can go as far as to say the Ugandans accepted he was Ugandan until the age of 18.
But we don't know. I mean, all we've got is the constitution. We haven't got anything to say whether or not it's a matter of law under the operation of Ugandan law. He A was never Ugandan, or B was Ugandan but lost it, and if so, at what date?
We don't have that, and my lord, absolutely right that you made that point earlier, and you're absolutely right. But we do not accept that there was evidence that which is incontrovertible evidence, the Ugandans accepted he was Ugandan until the age of 18. There just isn't that evidence. Yeah. And to go back to trite law in relation to, and this is an unlawful detention case ultimately, the burden of proof in relation to unlawful detention is on the respondent.
Yes, and the way they do that is by saying he's detained pursuant to a deportation order. And you say, oh, cripes. And then you've got to show that the deportation order was unlawful. And
Exactly.
the Secretary says no because he's...
Yes, so it slightly begs the question, but it's important that, of course, the deportation order not only has to be lawful, it has to remain lawful. So a deportation order can start off as being lawful and become unlawful. It's not a status that stays forever. Even if it is initially lawful, it has to remain lawful at all times.
And it's lawful actually until it's revoked, but then it ceases to be in effect from that stage or until it's quashed by a court of competent jurisdiction. Whether the detention continues to be lawful is another question.
Well, I'm not sure. We can develop that if necessary. I'm not sure we would accept that follows automatically. It probably. We perhaps could pause that, and if there's anything I'd like to come back on that. But I think. Sorry, just the last point. Yes.
It's not just that we accept there are circumstances when it's
Our case, as I'm sure the court appreciates, is that there's a linking between the statelessness in this case and the reasonableness of his detention. So there's we say a link to the two parts of the case, which the learned judge, we say, failed to properly link on the question of irremovability, because we say, really taking the point earlier, that if he was irremovable, that goes to the question of the lawfulness of the deportation order.
Yes, but hang on, haven't we jumped ahead rather? Mr. Deakin says you just look at, Mr. Deakin says, and the judge says, look at section 32(5). That says that the Secretary of State must, in certain circumstances, make a deportation order, and can only make a deportation order if the person is a foreign criminal.
Yeah.
And it is said your client clearly satisfies the requirements in that section being described as a foreign criminal because he's not a British citizen. This is talking about 2014, at the time of the deportation. He's not a British citizen. I think that's common ground.
Yes.
He's been convicted in the UK of an
Yes.
offence, and sentenced to a period of imprisonment of
Yes.
well over 12 months. So on the face of it, he's a foreign criminal. You say, however, that it is absurd for this to apply to somebody who is, you say, stateless.
Yes.
But that seems to me a different question. I think you're saying is, even if he is a foreign criminal within the meaning of Section 32, it is absurd for a deportation order to be made to a country of which he is in fact not a national, or to a country which will not let him in.
Yes. We link very intrinsically irremovability and statelessness. So in this case, we understand that it's arguable that merely being stateless is not enough, but we say it's not a violation of the Statelessness Convention to remove someone who is stateless but is still a threat to public order. For example, what is different here is that by virtue of the appellant's statelessness, he's become incapable of removal. It's the irremovability which makes the application of the regime
Can't
absurd.
remove him.
Yeah.
Why can't they make the order, which also has other consequences? If he does leave, it's a criminal offence to come back. If he does acquire another nationality, then he has to leave. I mean, they're not removing him. They're making an order which says he should leave, and the Secretary of State has power to remove him, but can't actually do it, in fact. That is very often the case with deportation orders. There are very many cases where it's made, but for a variety of reasons, they're not able to carry out that order. There are other consequences, any leave is invalidated and so on.
Well, the answer to that is we respectfully submit that there's going to be, and I think the court will accept this, irremovability is likely to affect a subset of stateless individuals. We do maintain that it's his statelessness which moves him irremovable, and that a deportation order in circumstances which really cannot have no effect is not something which is appropriate in terms of a regime to be put in place. As in the end, of course, we know the respondent appears to accept, because under Section 34(4) it does in fact withdraw the deportation order under Section 32.
Revoked the deportation.
Revoked it, yes.
Which may mean that...
I think
on
it's
that
withdraw. I
basis,
think the wording is withdrawal in
the
Section.
wording in the Act is withdraw a decision.
Yes.
And revoke the order.
Yes.
What about my Lord's point? Section 32(5) says the Secretary of State must make a deportation order in respect of the foreign criminal, subject to Section 33, and there are various exceptions in 33, two of which time including people who are also irremovable, and there is no exception for the stateless.
There's no reference to statelessness.
No.
Exactly. But that doesn't mean, we respectfully submit, that that means that the regime under the automatic deportation under Section 32 necessarily applies to individuals like the appellant, only a subset of stateless individuals, because clearly you could fall foul if you within those exceptions under Section 32 that if you do something that there's a whole, as we've seen under the regime under Section 33, if you fall foul of any of those, you can lose it. But those, of course, don't apply to the appellant. So the question is, in our respectful submission, what is the status? What is the effect, if any, of the deportation order regime in circumstances with an appellant here where his irremovability and statelessness are interconnected?
but you have to read section 32(5) as the Secretary of State must make a deportation order in respect of a foreign criminal, subject to section 33, and also if they are stateless.
Yes, we respectfully submit that still doesn't deal with the issue of the absurdity of making the deportation order in the first place.
But I don't see with respect why it's absurd. Well, if you could show that at the date of the making of the order, it was entirely obvious to the Secretary of State's officials that your client could never be removed from the UK, that might be different, but it's well short of that, isn't it?
Well, in that situation, my lord appears to be recognising that there may come to be circumstances that, factually, we would need to develop our case. I understand that, but there appears to be a recognition that the statutory absurdity point does have relevance. Certainly, if the respondent knows that there's no possibility or prospect of a stateless person going to another country. So, if that's recognised as a point in principle, then we would respectfully submit that is relevant to the question of the applicability of section 32 and 33 to the regime, because we still respectfully submit that one has to look at what is the reality in terms of a deportation order, the automatic deportation order regime in place. So, my lord says, and I understand where this comes from, that what was the state of mind of the Home Office, of the respondent at the relevant time, but appears to be recognising that there may be cases where the question of statelessness and irremovability are linked, as we respectfully submit, needs to be considered.
I don't know as much about deportation law as my Lord Justice Lewis and possibly others involved in the case, but suppose that the Secretary of State officials had made an order for your client's deportation, say, to Kazakhstan, so some state with which he never had any connection at all, no parents, nothing. One feels instinctively that that would be unlawful, but I don't know why.
Well, may the answer be section 5(2)? A deportation order against a person may at any time be revoked by a further order of the Secretary of State and shall cease to have effect if it becomes a British citizen. So the regime applies. An order under section 32 is actually an order under section 5. We know that from the interpretation section of law, we're not in the authority to find law. So if a situation came where somebody requested the Secretary of State to revoke the deportation order, and he says, in fact, the Ugandans, the Kazakhstans, have now confirmed they are not going to take me. It is now unlawful or unreasonable or irrational to maintain and enforce the deportation order. Then the question would arise as to whether or not it's irrational. The Secretary of State may or may not say, no, I want to maintain the order. I think he should leave. He can't leave at the moment, but he's a criminal. I want his leave invalidated. I want the deportation order to be there, so there'd be no risk of him getting British citizenship because he won't meet the good character requirements, then it'll be clear. And the court will have to assess all of that. So there will be consequences from the deportation order that the Secretary of State may or may not want to stay in place. The detention is a separate thing. He becomes liable to detention on the making of the order. And the question is it reasonable under Hardiel Singh to detain him and or to continue it?
Yes, my lord, that's very helpful. Two points really that that arise. First of all, as I know my lord knows, under section 5 of the Immigration Act, that specifically requires a person against whom a deportation order is made to leave the United Kingdom. That's what it sets in place, and that's our point, whether it finds favour with the court, but we respectfully, that's our point about the absurdity, regardless of the efforts to be made. In other words, it is just absurd to have a situation where Section 5, this is about a section to do leaving the United Kingdom, which is absolutely unenforceable at the time the deportation order is made.
May make a deportation order against him. That's defined as an order requiring him to leave and prohibiting from entering the United Kingdom. And it's an order which invalidates any leave to enter or remain in the United Kingdom given before the deportation order was made. So he clearly can't leave at the moment because he's not going to be admitted. If he applied for and got Ugandan nationality, he could leave. And we know nothing about whether or not he can get it.
We know nothing either way.
So he couldn't, arguably, you say, have left on the 17th of February 2014, because if he went to the Ugandan airport in Entebbe and said, I'm a Ugandan national, and produced his passport, and they said, yeah, but when did you actually, where were you born? How long have you been away? Then they might have turned him back. Or, as I say, we just don't know, he might have been able to register, but there may well be a situation where he can't leave. But there are other things that can happen from the deportation order, and the fact that an order can't in effect be fulfilled, does that make it an unlawful order?
Well, we say it does, and there's really 2 points. I'm going to repeat, I don't want to repeat our point ad nauseum because I want to go to a different point, which deals with my Lord's observation. But we say yes, that there is a statutory absurdity in relation to where a section specifically is there, where deportation is made to leave the United or not re-enter. It's about what that Section 5 really is about. That's the absurdity. But importantly, under Section 32(6), 32(6) states that the Secretary of State may not revoke a deportation order made in accordance with subsection 5, unless A, he thinks that an exception under Section 33 applies, B, the application for revocation is made while the foreign criminal is outside the United Kingdom, or Section 34(4) applies. So you have to read, our respectful submission, Section 5(2), Section 5 of the 1971 Act. 5(2) has to be read in light of Section 32(6) of the UK Borders Act 2007. So my Lord absolutely rightly observes we have to look at the question of a foreign criminal, meaning a person who is not a British citizen, convicted in the United Kingdom of offence, to whom condition 1 or 2 applies. And the Borders Act says that the Secretary of State may, at subsection 5, make a deportation order in respect to a foreign criminal subject to Section 33, but then 32(6) makes clear that you can only revoke a deportation order if A, B, or C apply. And we know ultimately that Section 34(4) is employed by the respondent to revoke the deportation order. So you can't see the 1971 Act, the Immigration Act 1971 Act, Section 5, in isolation. It has to be seen in the context of the UK Borders Act 2007.
But also, is it relevant to note that Section 33 of the UK Borders Act 33(7) says that the application of an exception in 33 doesn't prevent the making of a deportation order. So therefore, being somebody, for example, under exception 1, whose convention rights would be breached if they were deported, doesn't, it would seem, in itself under 33(7, means that perhaps the must, in 32 doesn't apply, but it doesn't prevent the making of a deportation order. So you can still have a deportation order despite the fact that to return you would be, for example, a breach of your convention rights. Isn't that something that weakens the position that you're taking in relation to absurdity from the beginning?
I think that's a good point. I think I
You
don't.
might want to come back to that.
Just give me a moment. But lady, I will deal with that point. We will come back to it, but
Thank you.
it's an important point, of course. But it's right to say, as my lady says, that section 33(7) does allows for the application of exception does not prevent the making of a deportation order, but it does go on to say that section 32(4) applies despite the application of exemption 1 or 4, but the timing, which is section 34, is important, and then we come to 34(4), which is what I've taken the court to. Secretary of State may withdraw a decision that section 32 applies or revoke a deportation award raised in accordance with 32(5) for the purpose of either taking action under the Immigration Act or rules and subsequently taking a new decision that section 32(5) applies and making a deportation order in accordance with section 32(5). So
In relation to the section 33 points, yeah, they don't concern somebody who is capable.
Yeah.
There are circumstances where they
Yeah.
here it's a physical.
Yeah. So I think the short answer to my lady's point is that those exceptions under section 33, which are there,
Yes.
some of which are transitory, some of which are
Yeah.
longer period, don't apply. They're incapable of applying in terms of removing a person from the United Kingdom. So
So I'm not following that.
I
What
don't
don't apply?
understand.
I may have missed that, sorry.
These that make it impossible to remove somebody. Impossible, as a matter of fact. Those circumstances, they can be a deportation order, and even though they fall under this exception, it's still practically possible to remove. I see. But we're dealing with that.
I'm assisting my learned junior with that. So I think the answer to your question is there's a difference. Section 33 exceptions clearly apply, but they have an application in terms of the deportation order still being valid in circumstances where it's still practically possible to remove. It's our submission that someone like the appellant is in a different category because it was simply incapable of being removed. So
What's the difference? I mean, you can't remove somebody if it's a breach of their European Convention rights because it would be illegal under Section 6 of the Human Rights Act to do that. You can't remove them if they're a refugee. I forget which provision of the Section 72 or 77 of the 2000 Act that says you can't remove somebody if they're going to be persecuted in the country that you're returning them to.
But that's slightly different, my lord. That doesn't necessarily, invalidate the deportation order in itself, because that's about the rights that the appellant could have under the European Convention or other rights that might mean that in practice, it might mean that he cannot be removed because of his situation and the effects of going to that country.
But it's the same thing. You're ordering to leave. I'm making a deportation order. You must leave. You're a citizen of Somalia. I'm making a deportation order. You must leave and go to Somalia. It would be illegal to send you to Somalia. And I suppose he could board a flight to Somalia and risk persecution there, but surely that isn't what Parliament
That's where we say the distinction lies. And I think we hope this deals with my lady's point. If in fact it will be a breach of a refugee convention or European Convention of Human Rights, that could make it unlawful to actually have that person sent and being received into another country. That is not the situation, our respectful position of here, where it's the country that is simply refusing to accept, because it would not be statutorily absurd to have a situation where a deportation order is put in place by which a potential appellant would have a right to say, I can't be sent to this country because that will breach my European Convention rights. That is not the same as we respectfully submit as here, where it was impossible from the outset because Uganda either knowingly, either the respondent knew or there was a reasonable belief that the Ugandan authorities would not accept the appellant. That is not the same, I respectful submission, to a situation where appellant may say that I can't go there because that will breach my European Convention, because the country itself isn't preventing their entry. It's albeit that their risk of a breach of the European Convention, for example, the Refugee Convention, by reason of the risk to them upon return to the country, is a different situation, our respectful submission, from a situation where it is known or should have been known that this deportation order could have no application. But that's why we tie in the statelessness and the irremovability, because it is different. If a country won't accept someone, they're irremovable to that country. Whereas the examples that were given by my lord are about breaches of convention, but it's not about the country. In other words, it turns on the appellant's rights.
May I put one more point, but it's still on ground one, but it is important. On the face of it, Section 32 applies to your client, but you say that there's an implied exception or qualification to avoid absurdity that foreign criminal can't mean somebody who is stateless.
Can't necessarily mean we're not. Our case is not that nobody who is stateless can. Section 32 could apply to some circumstances of where someone is stateless. If there are circumstances which, under the regime itself, apply. For example, the exceptions we talked about in Section 33. If there was something under the regime, we're not saying all stateless persons necessarily are accepted from the foreign definition of.
By virtue of the status.
It's limited to a small group, including the appellant, of where their statelessness and their irremovability are intrinsically linked. So foreign criminal, obviously foreign means non-British, we understand that. We're not saying that everybody who's stateless, the regime cannot apply. But if we say where as a matter of...
Stateless, you can't remove them. For the simple reason that nowhere will take them. You can send them all around the world on a cruise. No country will let them in. What stateless person is going to be allowed into? My definition of stateless means they have no state.
Yes, but that doesn't necessarily, in all circumstances, make the automatic deportation regime inapplicable to all persons who are stateless. I don't think we need to make the case as wide as that. We know on the facts of this case that the Ugandan authorities did not accept him. So I don't think we have to go as wide as to say that all non-British citizens who fall within the definition of foreign criminal.
Well, I hadn't actually put my point
Sorry,
yet. I was sort of running up to it. I'm slightly surprised by what you've just said, and it may be that Mr. Deacon would not argue that a person who is plainly de jure stateless could be deported. But anyway, the point I was coming to is this. There is no express exception for stateless persons in Section 33.
That's right. Contrast
the deprivation power under the British Nationality Act 1981. Secretary of State can deprive somebody of British citizenship if the Secretary of State thinks their presence is not conducive to the public good. There's an exception in that section, Section 40, subsection 5. Secretary of State may not make a deprivation order if the effect would be to render that person stateless. So, taking obvious, uncomplicated example, the Secretary of State can't deprive somebody of British citizenship if that's unarguably the only citizenship they have. Be no doubt met with rounds of applause if certain British citizens could be deprived of their citizenship, but they can't be if they've got nothing else left, putting it very broadly. But that's an express exception in the subsection. And it strikes me as a contrast with section 32 deportation, much more common event than deprivation, where there's a whole lot of express exceptions in section 33, but statelessness is not one of them. And moreover, it's the other point about section 33, which my lady has just put to you, that even if a section 33 exception applies, it doesn't mean that the making of the deprivation order was unlawful. It may mean that removal is impossible, but that's a different point.
Well, my lord, of course I understand that there may be a distinction drawn, and we cannot say that statelessness is specifically referred to. But what we say is, the respondent, we know, ultimately realised, and hence the withdrawal under section 34(4), realised that in the appellant's case, the irremovability and his statelessness were intimately connected. Because otherwise, one posits rhetorically, why would section 34(4) withdrawal of the section 32(5) be put into place?
May I just explore the section 34(4) with you?
Yes.
Take the person who's a refugee. They've come from a ghastly place where they'll be tortured. And the deportation is made because they're a foreign criminal. They can't be sent back to that country. The Secretary of State, would he be able to, under 34(4), say, right, I'm going to revoke the deportation order, that is, it ceases to have effect from now, not invalid from the beginning, but ceases to have effect now, going forward. So I can take other action under the rules, for example, giving discretionary leave for 30 months or whatever. And then in due course, and it may be years hence, and may never happen, if circumstances change in that country and a different regime is installed, then I will make a new deportation order. Could the Secretary of State do that under section 34(4)?
That's a good question. I'm not sure it's made clear. Under section 34(4), there's only two alternative bases of revocation. Either, as applicable in, appears to be applicable in the present case, where the original decision that section 32(5) applies is withdrawn, or what's called a snapback provision, which is where a deportation order is temporarily withdrawn, so a decision can be made under the immigration rules and the order is reimposed. That's a snapback. So
I think I don't think I necessarily accept that. There are two situations. The opening words may withdraw a decision. That is with a situation where a decision has been taken that section 32(5) applies, but the order hasn't yet been made, and then you withdraw it. And then it can also be revoked if you've already made it. It's a temporal thing as to whether you've got to the stage of just a decision or you've actually made the order. And the only purposes for which you can do it, according to 34(4), is for taking action, for example, under the immigration rules, and subsequently taking a new decision that section 325 applies. And you submit, I think, in your skeleton that those are cumulative. So if you're dealing with somebody who's a refugee, then presumably, because they've got to make the order, even though they can't be deported, they could revoke it, could they, under 34(4), to say, well, I'm going to revoke it, give you discretionary leave, and if in the fullness of time things get better in that country, we'll make a new order and deport you then. Could they do that?
I think assuming that the snapback doesn't apply, we're only in the first basis, which is the withdrawal of the section 32(5). I think that would be a recognition that that the deportation order can't apply. I don't know if it goes any further than reserving the respondent's right to serve something further down the line if things change. It is simply and quite narrowly construed Section 34(4) to be a withdrawal of the decision under Section 32(5). We say in this case, obviously, it's because he was in, as a matter of fact, irremovable by being stateless. But taking my Lord's point, I wonder if we were in the same terrain as we were earlier about whether, not to get confused between whether the appellant has rights not to be sent back to another country as opposed to the irremovability by reason of the rejection of a potential state that he could otherwise go to. So I think the answer to my Lord's question in our submission is that it is simply a withdrawal, which is where the original decision is no longer regarded as applicable. I'm not sure it builds in an express reservation to say, well, we might come back and do it again.
B, isn't it?
B is what, as I say, we've called that the snapback. That's where a deportation order is temporarily withdrawn so that a decision can be made under the immigration rules. It's usually relied upon where it's necessary to certify a protection claim that's clearly unfounded under Section 94 of the Nationality, Immigration and Asylum Act 2002. It is not a situation posited by my Lord of years down the line the regime itself changing. It is seen as a device to reimpose an order because of the clearly unfounded provision.
Mr. Max, I'm saying this to myself as well as to my colleagues. We'd better let you get on.
No, I'm sorry, my Lord.
You've been very helpful. We've asked a lot of questions. But,
if I may say that the court is really, it's helpful to have the court so engaged on these difficult questions. Really, there's very little more I can add in relation to the first ground.
Yes.
What we say is in relation to that is that for the reasons that we really advanced, as is recognised ultimately on the 26th of November 2019, the appellant was not subject to the automatic deportation regime under Section 32 of the 2007 Act, and that the withdrawal is important recognition of that position. And one asks rhetorically, and maybe Mr. Deacon can help, why otherwise would the deportation order be withdrawn if not to recognise the absurdity of having a deportation order in place that simply could not be progressed by reason of the connection of irremovability and statelessness. We give the alternative submission. I can take it very shortly. It's at page 15 of our submission. If we are wrong in relation to the non-applicability of the regime, we respectfully submit the learned judge erred by failing to give adequate reasons for his conclusions that the automatic deportation regime applied. And I don't want to say this too glibly, but I'm sure the court will not really dispute this, that he simply appeared to adopt the respondent's submissions. We've got that in the judgment at 1641 we've gone to, and also 1626. And although I make no criticism of the eloquent submissions of my learned friend in relation to those submissions, this was such a fundamental point. It required, in our respectful submission, proper analysis by the judge to distinguish between the points that really the court are now entertaining. This was not a simple, clear point that one could simply adopt submissions without explanation as to why the appellant's submissions were being rejected. And further alternatives, we respectfully submit, Sweeney C, D and E, further other short submissions, taking into account that the report was made on the false basis that the appellant was an Ugandan national, and in fact he wasn't at the relevant time. There were a failure to give adequate reasons for his conclusion that he was Ugandan. We've really covered that material very fully in relation to that lack of adequate reasons. We also respectfully submit he was wrong to hold that the respondent had a reasonable belief at all material times the appellant was Ugandan. We've gone to some of the source material as to why that could not be, in our respectful submission, a reasonable belief at the material time. Really, we've covered that in relation to the material on the, and we'll come to it briefly, on ground 3, in relation to the barriers to the appellant's removal, and he fails to give lack of reasons in relation to that. And finally, he seems to place reliance upon the distinction drawn by the respondent between de facto and de jure statelessness, and he deals with that at 1644A of the judgment, and there was no proper or basis in law to draw such a distinction. So that's our first ground. I'll just check if I've covered everything.
401 only gives the Secretary of State power to recognise somebody as de jure stateless. So that's
Yes.
not there.
If necessary on that. We've gone to the 401 rule that bless you, my lady. That really only goes to de jure statelessness.
It's the only power.
It's the only power. We've gone to 401, but that is clearly limited to jure. So again, we say that doesn't explain why the judge was able to distinguish between de facto and de jure, nor indeed does he give reasons why he does makes such a distinction. I can take the other grounds more shortly. I'm sure the court will be relieved to hear. I should be able to finish by the short adjournment. On ground 2, this is principle Hardy Singh 1, which perhaps should just. I don't think we need to go to the judgment because we've set it out, the relevant part, paragraph page 15 of our skeleton. This is the learned judge's findings at paragraph 175 in relation to finding an intention to deport, and that the power was only used lawfully and there was no intention to act unlawfully. We respectfully submit the learned judge failed in not finding that the respondent had breached the first Hardy-Singh principle. We perhaps need to just go briefly to the policy documents. The respondent, we say, failed without good reason to act in accordance with the stated policy conditions for removal on the EU letter. So that's at the supplementary bundle. Uh, 242. Makes the reference to the arrangements for removal, and we've gone to the source document, the EU letter, and there are policy documents in relation to how removal is effected. You'll see there that at 242 we have, and it's really the whole section. I'm not asking the court to go through it now, but it's really 2.4 arrangements for removal going through from paragraph 21 through to 26 in relation to that's the stated policy, and you can see that further at 379. Is where the we've gone through it already, the decision letter, and at 444. It's the supplementary bundle at 446.
Can you just tell me, page 444, because it's disembodied now, what exactly is this document? Is it in my notes?
Of the supplementary bundle?
Yeah.
Just give me one moment and I shall tell you.
Is it an internal guidance from the Secretary of State to immigration officers or what?
I think that's right. 1 second.
To consider when preparing EU letter.
This appears to be, I think these are policy documents of the respondents. So I think we can probably help you on, if you go to the front page, which is page 405, documents for enforced removal. I click at the relevant time, it's valid from 25th of February 2014.
We asked earlier whether there was a specimen EU letter anywhere in the bundles. I don't know
don't think there is. What I can help a little bit is at 379. I think we may have gone to this document already, but I'm not sure we have actually, but we did touch upon it. 379, removal of Ugandan national may only proceed with following criteria met. There's no dispute or doubt that Ugandan nationality supported by original expired Ugandan passport or other good supporting evidence. And at the bottom, last paragraph, please note that the highest quality of EULs and supporting evidence is crucial not only to maintaining our EUL arrangements, but also to ensuring that Ugandan officials can quickly identify the individual as Ugandan.
Can you again please just tell me what this document is and what is the date of this document? It appears to be a disembodied page at the moment.
Is this 379, my lord? I probably can. 1 second. We think this came from the respondent. I think
disclosed as relevant.
Yeah. My lord, I can't give an answer to your question, but it was disclosed by the respondent as being a
That
relevant.
was after lunch, actually. Yeah.
Yeah, it's a relevant document. 444 to 446 deals with documents for enforced removals, and it really repeats the point that's made at 379 in that policy document. And we know when this is valid from February 2014. Second entry, you must maintain the highest possible standards in both the production and use of EUL, must increase as fully and comprehensively as possible. At the bottom of that page, nationality checks. If there's any doubt about a person's nationality and identity, do not assume the CID identity and or nationality is correct. You must test and review the information provided for documentation interview. If there is emerging evidence of different nationality and you cannot fully evidence a claimed nationality, you must not use an EUL. If there's any doubt about the person's nationality and identity, do not use an EU letter. And you'll see it 446 under the EU letter. Personal details including name, nationality, date of birth, precise place of birth is one of the prerequisites. And finally, for these purposes, at 456.
Where is that? You're going to
446, my lord. Do you see it?
You've taken us to do, but it would help me for my note if you could tell me which bits of this thing you call a policy document was not complied with, rendering the decision to make the deportation unlawful because we can infer from it that there was no intention to.
Yeah, it is our case that the respondent.
Just show me which bullet points exactly.
Yes, certainly, my lord. So it's originally 444.
Yeah.
It's really it's the second paragraph, initial redocumentation action. It's that part. There has to be completion fully and comprehensively if possible, and then more fundamentally, the
Did
first.
you say there was a breach of that?
Yes, the last bullet point at 444.
Yes.
Any doubt about the nationality, and it's the first 3 bullet points at 444/445.
Emerging evidence.
Yep.
Doubt.
Yes, and then
Unlikely to dispute.
yes, and then at 446, it's the second bullet point under EU letter. And then at 456, last to complete the point, interim operational instruction, last part of 456, this is 6th October 2014. Background, it's the last sentence. EULs are only to be used where there is specific evidence of Ugandan nationality and identity. In the absence of such evidence, but where we suspect the person from Uganda, an ETD application must be submitted. And again, I think we've gone to it, next page 457, we've really gone to that, but the interim operation instruction includes the reference to the birth certificate. We know on this case that the respondent has secured approval for an EU letter for the applicant, for the appellant from the Ugandan High Commission on the basis of information which we respectfully submit the respondent knew or ought to have known was materially misleading. Perhaps I should have also asked my Lord Justice Lewis's question as to what parts that we say were wrongly observed, not observed properly. So it's at 445. The biodata. You see the last bullet point
I
at
noticed
445.
you hadn't mentioned it, but you do include it, right?
We do, yes. That was my omission, not to be ignored. We say that was how approval was secured.
And materially misleading is that simply the failure to provide a copy of the birth certificate.
But also to state that he was born in Rware on the biodata.
Yes. Plus the material we've gone to already shows wrongly that he stated that the biodata says he was born in Rware, where that was clearly wrong. And the respondent had confirmation of the position by that time from the hospital. They'd made those inquiries, had the information from the hospital that said he was born in London, and they relied upon the biodata. And my lady really saw the point that when one looks at the biodata, there's clearly an error that's crept in, and that error was relied upon wrongly in relation to the approval that was sought. So it was misleading information.
With due respect, yes.
And so therefore we say that the judge was wrong to conclude it was unnecessary to make findings in relation to those points which are set out in paragraph 35 of our submissions, and what flowed from that, we say being a species of lawful removal, the intention to deport implied an intention to effect removal in a lawful manner, and therefore by reason of that, if there was an intention to remove the appellant in the manner that was not lawful, that there was no longer an intention to deport, just an intention to remove, which, if that was right, means a breach of the first Hardiel-Singh principle. And further alternative, we say, failed to give adequate reasons. So that deals with the first Hardiel-Singh point. I think I can complete shortly if I can trespass a short period. At ground 3, Hardiel-Singh 2 and 3, we further submit the learned judge failed to err in law because he found the detention satisfied Hardiel-Singh 2 and 3. His conclusion, and we don't need to go to it now, at 207 of his judgment, that the respondent's initial detention minute evinced a recognition that overcoming the barriers to the appellant's removal would likely take some considerable time to complete, together with the rest of the evidence. So he made that finding, together with the rest of the evidence as to the respondent's knowledge of the difficulties in removal, inadequately documented individuals to Uganda. We spent a long time looking at all that material. He further alternatively did not give adequate reasons in failing to regard the appellant's detention. He failed to explore the extent to which the respondent was under a duty of proper inquiry in relation to the appellant's place of birth, nor the extent to which that duty, if it existed, was satisfied. He failed properly or at all to explain, especially what was recorded at paragraph 27 of the judgment, difficulties encountered with the quote, 2 other proposed returns to Uganda, what had been learnt from what was described as the complex issues, and we've gone to that, which had arisen in relation to that, did not throw into question the appellant's removability. And we've footnoted the limited observations or findings at paragraphs 208, 10, and 11 of the judgment, and that he failed properly to explain why the meeting of the 25th of September 2015, which we've gone to, and the earlier communications from the Ugandan High Commission, indicating that individuals in the appellant's position would lose any right to Ugandan citizenship. And if necessary, we can find that. I don't think I need to ask you to go to it now, but it's worth noting at supplementary bundle 374 to 377. Did not fix the respondent with knowledge and or reasonable belief that the appellant was not in fact a Ugandan national and or removable to Uganda at all. So 374 to 377 are relevant to this question because, and we've gone to it already, in relation to the difficulties which happened in other cases and the understanding at the relevant time of the fact the Ugandan High Commission were unlikely to accept him, and that should have been very much the learned judge's mind in terms of his explanation and findings in relation to the respondent's state of knowledge or reasonable belief. And he failed properly or at all to consider the Ugandan authorities were provided materially misleading evidence. We've gone to that. And in particular, failed completely to note that there was an incomplete, we say, complete biodata form, which wrongly recorded the appellant's place of birth in Uganda, notwithstanding the respondent was aware of the appellant's UK birth certificate, which it was recognised accorded a presumption in his favour upon initial detention he was born here. And finally, in this regard, failed to consider how all the evidence impacted upon his argument that the respondent had constructive knowledge of the impossibility, really, of returning the appellant to Uganda, so that we say it could not have maintained a reasonable belief as to his removal within a reasonable time. We say the learned judge, again, adopted the submissions of the very eloquent submissions, albeit the submissions of the respondent's counsel without proper analysis, and that evinces a lack of proper judicial engagement. He failed to explore the extent to which the attention of ETD colleagues was drawn to the crucial uncertainty, and it was a huge point in relation to the appellant's place of birth, nor to what extent, if a mere green light confirmation by one part of the respondent could operate to exculpate liability where we knew, and where it was known, another part of the respondent had relevant knowledge that should have alerted the respondent to the impossibility of removal. That's really a constructive knowledge point, and failed to record or grapple with the difficulties of the biodata form, which was inaccurate. And in failing to make specific findings in relation to evidence as to the response material misdirection of the Ugandan authorities, or on or around the date of the appellant's attempted removal, he covered the evidence by referring the cloak of his determination not to consider the question of the material misdirection, so he simply failed to engage on that at 1752, and more significantly, failed anywhere in the judgment to make any reference to, let alone properly engage with the important GCID note dated the 9th of December 2014. It was recorded, it's fair to say, at paragraph 56 of the judgment, but was otherwise not engaged. And this was obviously a very important point relied upon by the appellant, and failed to consider further the significance in relation to constructive knowledge. Finally, on this point, the learned judge failed to make specific findings following the detention review on the 11th of March 2015, saying that the only barrier to the appellant's removal was securing an ETD in relation to the apparent non-appreciation by the respondent as to the requirement in securing that to submit the appellant's full UK birth certificate. And we've seen that at supplementary bundle 457. These were important, crucial findings in order to determine whether the respondent had a reasonable belief that the appellant remained removable within a reasonable time frame. The learned judge failed to do that, and failed also to consider the impact of the removal of the appellant to Uganda should have had upon the respondent's expectation or belief that the second removal could be effected with a reasonable time after the failed removal in that December 2014. That failure was especially noteworthy given the impasse arising out of the failed removal, the need for a higher level of certainty as to removal, as required by the increased length of his detention. And more generally, he failed to make any findings or adequate findings in relation to aspects of the detention review, specifically the 19th of January 2015, the 16th of February 2015, the 3rd of March, the 16th of March, and the 13th of April 2015, when it was recognised the position was confusing and the respondent's was a difficult case. We've got the citations of that at the very end of our skeleton supplementary bundle.
Page 20 of your skeleton
Exactly.
sets it out very
We've gone to
helpfully.
the supplementary bundle. In relation to that. And again, we respectfully submit the learned judge erred in his findings that there were no breaches of Articles 2 and 3 of the principles. And finally, as I say, it's really an overall ground fall, which I shan't spend any time on. It's dealt with very shortly. It's summarised at paragraph 38. It was a failure to properly evaluate the evidence provided by Sharon Buckle, and all the points really we've already gone through in relation to the incomplete and inaccurate biodata form and the failure to send by the respondent to send the appellant birth certificate to the authorities and failed to make reference to the important GCID note of the 9th December 2014. We respectfully submit that ground 4 doesn't cover much different ground from grounds 1 to 3, which is why I'm not spending any particular time on it, but it does have a standalone existence as was recognised when permission was granted in the first place. My lords, my lady, those are our primary submissions. I'm sorry it took so long, the early part, but I think it's helpful. I haven't, as I've said, dealt with the res judicata point. That is covered in our skeleton, supplementary skeleton, but unless the court requires otherwise, I was going to reserve that to see whether and to what extent the
I
respondent
don't think
relying
you need
upon
to
it.
deal with it now.
So just check one thing. Oh yes, so two very short additional points, please. The first is this, that on the birth certificate confirmation, the judge, and perhaps we just need to very briefly go to paragraph 206 of the judgment. So that's at page 209.
Yes.
He said he found the arguments that Mr. Deakin telling. The judgment, there's a record of the investigations of the birth certificate, but no evidence of response to that request, to the facts, to the Central Middlesex Hospital. No confirmation of the claimant's place of birth until the 20th of July 2015. The auto deport minute before the court noted that confirmation had been received from the hospital by phone. So,
but they requested written confirmation as well, and the written confirmation never came. As I recollect the memo that you showed us this morning, is that correct?
That is correct.
it is correct. There's no written confirmation, but there's a material error because by incorporation, it appears the judge records no confirmation as opposed to no written confirmation. So that was not actually right because they did know the true position, which the judge doesn't record. And finally, last point, which is at paragraph 218 of the judgment, 2 pages on at page 211, in relation to, and it's dealt with the belief as the Sharon Buckle's belief as reviewing officer. I'll take you very briefly to something she said at the supplement. Well, I can give you the quote. It's the supplementary bundle at 41D to 42E. It was clear, until it was certain it would not be accepted back. Believed the detention was proportionate, and we can see if I just finish this point. So that's what was found at 211, and at supplementary bundle at page 281. I think we've gone through this before. This is the point about what was the state of play at 281 and the qualification. I think I've taken you to when Ms. Bassel gave evidence, supplementary bundle 41D to 42E.
I'm not sure what point you're making. It's my fault entirely. I just don't know what point you're making.
The point.
Yes. So it's a question of whether the learning judge failed to engage on the standard that was applicable, because it looks like when Sharon Buckwell said it was until he was certain he would not be accepted back, it was believed the detention was proportionate, that certain was much too high a threshold test, and the judge did not engage in that. The judge seems to have accepted Ms. Buckle's evidence that the question of proportionality turns only on the questions of certainty that he wouldn't be accepted back into Uganda, as opposed to whether it was a reasonable belief.
And this is a flaw in paragraph 211 of the judgment.
Yes. 218.
218.
There's just no reference.
There's just simply no engagement as to what is the appropriate. I mean, Ms. Buckle saying, accepting as she did at 41D to 42E, that then the respondent was certain he would not be accepted back, that made the detention proportionate. That was not the test to apply. It's not a question of certainty. It's a question of assessing the evidence as to reasonableness.
So it goes on to say it's more likely than not. We're missing. Sorry.
This really is almost a last point that I know my Lone Junior was keen for me to advance. We probably just need.
Are you saying there's something missing from you're not saying the words on the page are wrong, you're saying he hasn't looked at something else. He hasn't said to himself, oh, if I read Miss Buckle's witness statement again, she's used the wrong test and too high a test, and therefore...
I think it was her evidence in cross-examination.
And he hasn't included that in paragraph 218, and if he had included it, he'd have realised she was using the wrong test.
Yes.
Well, at least
he needs to have to engage what the test is. It seems to have assumed that of itself answered the point, that certainty of non-return, non-acceptance stood as itself. We needed to analyse what would be reasonable to make the detention lawful. My instructing solicitors have asked me one point. I'm very sorry.
Yeah.
Yeah, I'm sure the court has this, but since my instructing solicitors have asked me to raise it, I will. Of course, the court also has to consider not simply the early part of detention, the initial part of detention, but also the second part of detention when he's returned from Uganda.
December 9th, yeah.
Exactly, I'm sure the court has
Yes,
that in mind.
well, we have to.
It's the totality.
We have to consider whether all or any of the period from March 2014, after the admitted unlawful period, to June 2015.
Yes. I'm sure the court has that in mind, but just
We do.
to be sure. I'm very grateful. That's all I wish to say.
Thank you very much indeed. We'll return at 2:10.
Did I get something wrong at the end?
No. We just need to.
I haven't spoken.
I was just saying, well done to him. Listen, I just need to double check that last reference. But I wanted to, yeah, let's go outside. The doors are.
Honestly.
Is he going to be locked here?
Yeah.
I might take my computer. Yeah. What time are you out?
5 to.
I'll leave my stuff here. Should we meet at?
Yeah, I just wanted to.
No one can get lunch.
That's the only one. That's the only one.
I'll be in. Yeah, I'm going to put it like yeah. Yeah, I really want to go in there. I'm waiting for you.
We can leave things.
can leave this here, can't I? Just take these with me, sorry. Oh. Sorry. Are we still being recorded?